Hello, my name is Jessie Krapser, and I'm going to present for you the legal aspects of search and seizure in the workplace. Let's get started with some basics about an employee's right to privacy in the workplace. First, there is no absolute right to privacy in the workplace for employees. However, there are some aspects of workplace privacy that may be protected by the Constitution, namely the Fourth Amendment, with federal or state statutes, or through common law. These protections differ between public and private employers. There are countless scenarios of search and seizure in the workplace. In turn, this area of law is still developing. The leading case law on issues of search and seizure in the workplace is Connor v. Ortega, which was decided on March 31, 1987, in a split decision by the Supreme Court of the United States. This case arose over unwarranted search of Magno J. Ortega's workspace by his employer, Napa State Hospital. Now, let's review the elements of the case and what was decided. First, the employee's perspective of the event was as follows. The employee was approached by a hospital official and placed on administrative leave while being investigated for several potential workplace misconduct violations. Ortega asked for and was granted 2 weeks vacation rather than administrative leave. This left him with the impression that he was still employed as normal. No procedures were in place for search and seizure if an employee is on administrative leave. Ortega felt he had a reasonable expectation to privacy in his office as he did not share it with anyone. While on vacation, the investigation continued and led them to his office where he had many personal items throughout his desk and file cabinet. And while he was gone, the hospital raided, which Ortega felt violated his Fourth Amendment right to be free from warrantless search and seizures. The hospital staff who performed the investigation provided no clear procedure for inventorying the employee's office. And the employee was terminated upon completion of the investigation. He never returned to work after his leave. The Fourth Amendment of the Constitution provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Now, let's talk about the employer's perspective of the event. The hospital had 3 suspicions of misconduct. The 3 suspicions were not related in nature. 1, mismanagement of finances. 2, sexual harassment. And 3, inappropriate disciplinary action of another employee. The employee was placed on administrative leave, but then granted 2 weeks of vacation. The investigation took place while he was gone. When the 2 weeks were up, the officials placed him on administrative leave. Now, the hospital officials performing the investigation searched the employee's office, removing state-owned as well as personal items of the employee. Items were removed from the office desk and filing cabinet. The officials boxed up the employee's personal items and placed them in boxes for the employee to pick up later. And the hospital performed the investigation, including search and seizure, under what they thought were company procedures. The officials retrieved personal effects in the search that were later used in a hearing to prove misconduct and have him fired. Now, the results of the case. In the district court, They agreed that the search was necessary to acquire state property and that Ortega might be in possession of. They affirmed that the hospital was correct in its search and seizure and that the Fourth Amendment was not violated. There was no need to secure state property in Ortega's office was necessary and legal. And then the decision was appealed by Ortega. That's when it went to the appeals court. The appeals court reversed the lower court decision. They concluded that Ortega had a reasonable expectation of privacy. The judgment was reversed and remanded to the district court. The judges concluded searches by government are subject to Fourth Amendment restraints. So now the hospital appealed to the Supreme Court of the United States. Now on to the Supreme Court. The court reversed the lower court's decision and remanded the case to the lower courts, so they agreed with the appeals court. Justice Scalia concluded that within office spaces, drawers and files are protected by the Fourth Amendment. Justice O'Connor and the Chief Justice, Justice White, and Justice Powell agreed that Ortega had reasonable expectations of privacy in his office desk and the file cabinets at his workspace. It was a 5-4 vote in favor of Petitioner Ortega, so you can see it was a very close case. And it's a very complicated case, with the outcome being that the Supreme Court agreed the Fourth Amendment was violated as the hospital searched and seized private property that should have been obtained by a warrant. It is important to note that the Supreme Court did not decide the final outcome of this case. The court decides how the law should be applied to a particular set of circumstances and asks the lower courts to make the ruling based on the facts of the case. So they do not diagnose what the facts are and what's present. That is what is meant by remanding the case to the lower courts. So, what area of law was decided by the Supreme Court, you ask? Good question. So, public employees have a reasonable expectation of privacy in desks or filing cabinets, and this area is protected by Fourth Amendment rights. However, warrantless searches of desks and filing cabinets are permissible if the employer has reasonable suspicion that workplace misconduct has occurred and the search is performed in expectation that evidence will be discovered to prove the misconduct, or the search is necessary for a non-investigatory work-related purpose, such as retrieving a file. So, the test that the Supreme Court developed to decide if a warrantless search is appropriate in an area in which an employee has an expectation of privacy is: was the search reasonable? The employer has reason to believe a search is necessary. For example, the employee has been implicated in committing workplace misconduct, and a search will turn up evidence related to the misconduct. A warrant, and it's important on that they're only searching for that evidence, that they're not just going on a wild goose chase. Then, in this case, a warrantless search is acceptable of the employee's desk and filing cabinet. So let's go over the what areas inherently constitute an unreasonable and reasonable expectations of privacy in the workplace. First, reasonable areas to expect privacy are body and physical space, like a pat down, your purse, your briefcase, your personal information. They shouldn't be accessing that without permission. And next, the unreasonable areas to expect privacy include common areas, your work area, meaning the top of your desk or workstation, your work phone, your work email account, your work computer, and basically any business-related equipment provided by your employer. Now, what could have been done differently? Consent from Ortega to have the search that area could have been obtained. The hospital could have invited Ortega when searching the area. A warrant to search the private area of the office could have been obtained just to avoid litigation. The violation could have been discussed with Ortega and required that he resign based on evidence from the complaints received. An attorney-approved search policy should have been in place and been communicated to and signed by employees. And at minimum, private property at his office should have been avoided. So, how does this apply to a private employer, you ask? Well, the Fourth Amendment does not offer protections to private employers. In fact, private employers have fewer privacy rights than public employees. Arbitration is a common dispute resolution process for private employers and their employees. However, all is not lost, as some common law and statutory laws apply to the private sector. One such law, intrusion into seclusion, is a tort law that exists as a remedy for employees who prove that their employer intentionally intruded into a private area the employee was entitled to privacy in said area. The intrusion would be objectionable to a person of reasonable sensitivity. What is the takeaway here? Protections from searches differ between public and private employers. Employers need search policies, and they need to follow the guidelines of said policies by circulating them to employees in order to minimize their legal liability. And employees need to be aware of search policies and store any items they would like to remain private at home. Thank you very much. Please feel free to post any feedback or questions you have about search and seizure in the workplace.